make any reservation if you cannot close your evidence if you still have to present witnesses. The proper thing to do is to ask for continuance.
Your Honor, please.
What's the pleasure of the...
Yesterday, I thought we were agreed together with the Honorable Court, Your Honor, that the enumerated impeachment articles, Your Honor, that were not touched upon will be considered as abandoned or dismissed.
That's true.
Not only because...
As far as the Article 1, Article 4, 5, 6, and 8. 5.
That's correct, Your Honor.
That's already effectively withdrawn.
Yeah.
That is clear. I clarified that yesterday.
And we were merely discussing, Your Honor, the modality or the means by which the same could be effected. There were some suggestions that a mere notice will be more than enough. We were of the impression that a motion to dismiss is necessary because there is already an answer filed, and as in fact there had been trial going on. So that matter of how to dismiss the four impeachment articles, Your Honor, will be effected is left to the discretion of the prosecution, Your Honor. But now comes another development, Your Honor, with this lot of reservations and so on, calling the Chief Justice Renato to the stand. Maybe is another turning back from the original position that was manifested by the Chief Prosecutor before this Honorable Court, Your Honor. We just invite the attention of the Court on that matter, Your Honor.
Yesterday I clarified. I think the records of these proceedings will bear me out. Whether there's no question about the 5 articles withdrawn. That's clear in the record. And it was also clear to this presiding officer that the prosecution was terminating the presentation of its evidence with respect to Article 3 and Article 7. In fact, in the case of Article
2, 3, and 7.
3, Article 3, they did not only manifested that they were terminating the presentation of evidence, they cut down the allegation. They retained only in Article 3 flip-flopping. But as far as the entanglement with of the defendant with the former President, Madam Mrs. Gloria Macapagal-Arroyo, as well as talking to litigants as a basis of their charge that he did not follow the stringent requirement of probity, integrity, competence, and independence. They have already also withdrawn that. They have also decided to take that out and do not present any evidence on it. So, but they made a reservation only with respect to Article 2. And that is because there is a pending case. And understandably, the court was aware of that because there is a pending case in the Supreme Court whether impeachment is an implied exception to the confidentiality of foreign currency deposits. So I would like to be clarified.
Yes, sir. Mr. President, we are sticking to our earlier manifestation that we are we are terminating the presentation of our evidence subject to one reservation, and that is The reservation is with respect to the dollar accounts of the
Only.
Chief Justice.
Only.
Yes, sir.
And you are not going to ask Justice Sereno anymore?
No
to
more,
come to
no
this
more,
court?
no
All
more.
right. So,
And I just want to make a manifestation that yesterday, my math was wrong. When I stated that with respect to the documents that we have marked so far, 166 documents for Article 2, 16 documents for Article 3, and 65 documents for Article 7. The total, I said yesterday, was 390 documentary evidence, but it was just 247. So 247 documents, Your Honor. And also, Mr. President, what we manifested and what we stated even outside of this honorable tribunal with respect to the termination of the presentation of evidence was that we felt that we have already presented a strong case.
all right.
And even when we, even outside this honorable tribunal, Mr. President, we're saying that it is really up to the tribunal to decide, to appreciate. And we're just stating our advocacy without prejudging the outcome of the resolution, because we have high respect to this honorable tribunal. We just want that to make, we just want that to put on record those statement, Mr. President.
All right. We accept that explanation. Now, what is your pleasure? When are you going to make your offer of evidence?
We are now,
Especially documentary evidence.
yes, documentary. We are now requesting the honorable tribunal through the honorable presiding officer to give us the prosecution until Friday this week. That's 2 days from today, within which to
3 days. 3 days.
yes,
To file.
to file our written formal offer of documentary evidence.
Yes, and list them down.
Yes,
And then we will also give the defense enough time to go over it with copy furnished.
Maybe
we will do that,
May we
Mr.
request-
President.
May we request, Your Honor, if it is not asking too much, a 5-day period within which to signify our objection or conformity to the offer that
All
will
right.
be made.
That's a
receipt, Your
reasonable
Honor.
request. So when you file your pleading to formally offer your documentary evidence, testimonial documentary evidence to this court in writing, not send a copy to the defense, and the defense will have 5 days
From receipt,
from
Mr.
receipt of your
formal offer.
formal offer in writing to file their objection to your documentary evidence.
Mr. President, we will submit our documentary offer of evidence, documentary evidence on Friday. Friday this week, that's 2 days from today. And we understand that the Senate has set a caucus also on Monday. Probably it will be reasonable, Mr. President, that to ask the defense to submit it also, if not 2 days, 3 days. For us, we will submit it 2 days from today.
Yeah, but
And if I may finish, in fact, there's already a submission of the suppression of evidence with respect to Article 2.
You know,
and 166 documents pertain to Article 2. So we're just suggesting, Mr.
Counsel,
President.
just a minute. You know, for the prosecution, all you have to do is actually to list these documents
in State
in
Department.
some pieces of paper and list them down. But the defense, to be fair to them, they'll have to analyze what those documents are and to state their objections for their admissibility. So 5 days is a reasonable time.
We submit, Mr.
All right.
President.
So ordered.
Thank you, Your Honor.
Now, When will the defense start its presentation of its evidence in chief?
We will await the ruling of this court, Your Honor, after the order is made relative to the admissibility of the offered evidence, Your Honor.
To expedite the proceedings, would it not be possible to start the presentation of the testimonial or whatever evidence the defense would make and then we will deal with the objections of the defense on the offered evidence of the prosecution?
Your Honor, please, we wanted to do that, and by way of accommodating the court, in order that the general public may not have the impression that we are delaying the proceedings in this case, Your Honor. But there are so many things that may come up, Your Honor, in our observation, opposition, as against the admissibility, of these documents, Your Honor. Insofar as the prosecution is concerned, these evidences are with them. They have examined it, they have made a formal offer of the same. But insofar as the defense is concerned, Your Honor, we have to analyze it is not enough that they are listed as being offered. We have to analyze what is the purpose of the offer. They may be admitted on certain grounds, Your Honor, but decidedly they may not be admitted in consonance with the purpose for which they are offered. That is our position,
right.
Your Honor.
Mr. President, if we may,
Yes.
we are constrained to object to that proposal, because if we will submit
What proposal,
the proposal of
the chair, of the chair?
No, it's not the chair's proposal, but the proposal of the defense to submit or to present their evidence only after the ruling of the Senate on the admissibility, if I may finish.
Yeah, that is the most...
If I can.
Go ahead, I'm sorry.
The floor. Thank you. Because if that is so, Mr. President, we asked for 2 days to submit our formal offer of evidence, and that will be Friday. And the chair gave 5 days to the defense. And if you count that, it would be Wednesday. And from tomorrow until Wednesday, if we will follow the proposal, there will be no hearing. And to us, it is a waste of time of this honorable court.
Many a times...
Mr. President, that is the position. That is the position of the prosecution.
Your Honor, please, many a times we have been over-liberal and magnanimous to the prosecution, Your Honor. They come here, no evidence, no witness, the case is, the setting is postponed, Your Honor, and we had never been heard to complain, Your Honor. We had been very accommodating. Now, if they wanted a very strict application of the rules, we will meet them head-on, Your Honor.
But Mr.
Well, there are various evidence here presented, documentary at that. If they are overruled, if they are rejected, why are we going to touch them in the presentation of our evidence, Your Honor? On the other hand, there is even a motion filed by us to suppress and or to delete from the record, Your Honor, the documentary evidence consisting of bank records, which we feel are in violation of the rule on regarding privacy pursuant to Republic Act 1405, Your Honor. Why will we be deprived simply because you wanted us to go the way you wanted to? There is nothing that the prosecution can impose upon this defense, Your Honor. Never been unreasonable.
Sir, I just have to respond to that. There's a statement.
Yes,
with respect to the prosecution not being prepared, to the prosecution not ready, and to me that's uncalled for. To us, I just want to put on record, Mr. President.
I'll stake on the record of making.
It's okay if you stake on the record, but Mr. President, we want to put on record that